Well, thank you very much for the introduction. Good morning, everyone. As Bav just said, my name is Eamon Chalk. I'm an IP solicitor at Briffa. For those of you who haven't heard of us or don't know us, we're a specialist IP and IT law firm. We've been going for about 25 years, and we are members of the Knowledge Quarter for the last 5 years or so. Active members and big fans, and we're based in the Business Design Centre in Angel, so we're on the eastern extremity of the Knowledge Quarter mile. The reason for this talk, or the thing that catalyzed this talk, is that we've all lived our lives online for the last year or more. Almost all of us will have at some point over that period been online, gaming online, social online, dating, getting our news online. Many of us will have experienced religious ceremonies for the first time online, funerals and other services. And importantly, for the purposes of this talk, we've been doing business online. And doing business for some people will mean working from home for an employer. For others, it will mean setting up a new business for the first time, selling a service online, selling products online, and in some cases both. And all of those activities will have involved a huge amount of data, a huge amount of information, a huge amount of content being put into the online realm, much, much more so than before. When I sat to think about this, I tried to put a framework around it and think about all the potential issues that you might have to think about when you are considering the online realm. And there are a myriad of issues and competing interests. From a commercial perspective, regulation of buying, selling, and advertising is an obvious one, but there are competing interests there. You have to think about the freedom to trade, but you also have to think about the restrictions on that freedom, so that you prevent things like unfair selling, misleading advertising, and so on. On a more broader level, you think about things like, well, how do you regulate search engines and social media? And again, there are competing interests around freedom of speech, freedom from harassment and cyberstalking, privacy, intellectual property infringement. A really specific example that we saw examples of in the last few years were regulation of political campaigns. In 2016, there was pages and pages written about how do you respect free speech, free political speech, whilst also preventing things like disinformation and fake news. And then I guess at the more extreme end of the spectrum, you have things like terrorism, extremism, and hate crime online. And again, there are competing interests there. So I don't propose to deal with all of those things in any level of detail. I just put those things up there to broaden our frame of thought and our frame of discussion. Because very often when you're thinking about a commercial question or a commercial problem rather that involves the online realm, these types of issues very often do creep in. For one example, we often advise people who are influencers or who buy and sell using Instagram. And if they come to us with a complaint of IP infringement, there's very often also an element of defamation online or some type of trolling or some type of other online harm that we also need to think about. So it's a new and complex area. But for the purposes of today's talk, we're going to try and focus on three things: copyright, data protection, and trademarks. And in those three spheres, we're thinking about ownership rules relating to the content that's being put up online, privacy rights relating to the content that's being put up online, and brand rights relating to online content. And in each of those sections, I'm going to try and look at it from both perspectives. So if you're the owner of the copyright content, or you're the data subject, or you're the trademark owner, what do you want to think about if you're running your own business, or if you're putting your own content up there? What safeguards do you need? And then we'll flip it around and look at it from the other perspective. If you're someone whose job it is to deal with copyright content, to deal with personal data, to deal with branded products and put them online, what do you need to think about to protect yourself, to protect your business, and to make sure you're respecting other people's IP rights and privacy rights, and that you're behaving lawfully? So we'll jump right into the first of those sections, which is copyright. And I suppose the first thing to say about copyright is it's an incredibly important and valuable intellectual property right, principally because it protects a very broad range of subject matter, a broad range of original works. And there are two concepts to unpick there. The first is that for a work to be protectable, it must be original. And the second is that it must actually constitute a work in the copyright sense. And an important thing to point out is that original in this context doesn't mean new or novel. Novel is a concept that we're familiar with in IP law because it relates to patents. If you want to patent a design, if you want to patent an invention, or to protect a registered design, it has to be new in the sense that it can't have existed before anywhere in the world. Whereas original in the copyright sense doesn't mean that something has to be new in that sense. It doesn't mean that the thing can never have existed before. It means that it must have originated from an author, original in that sense. It must not be copied. And then when we're assessing originality, what we're looking for is the skill, labor, and judgment of the author, or under the EU test, the broader test, we're looking for the author's own intellectual creation that gone into the creation of a creative work. And it's a relatively low threshold. I could pick up a piece of paper and draw a cat on page, and that would be sufficiently original to qualify for protection as an artistic work. And there's no requirement of artistic merit, there's no requirement of creative merit. So it's neutral in that sense of the assessment. And then what does a work mean? Well, again, there are a very, very broad spectrum of works and materials, but they are categorized. So literary works are included, and that includes software code, blogs, and micro works. So there was an InfoPack case where the court held that even 11-word snippets of news articles or news information qualified in their own right as copyright works. So it is quite flexible in that sense. Artistic works are covered, including photographs, diagrams, maps, and so on. Audio and sound recordings are protected, films are protected. And for the purposes of this talk, I thought it was important to emphasize the protection for databases, because a database is a collection of individual works arranged or accessible in a systematic or methodical way. So if you have a database, the individual works in the database are copyright works in their own right. It could be a collection of literary works, artistic works, recorded works, but separately database copyright work, which is also protectable. And the skill, labor, and judgment that has gone into the arrangement and compilation and amalgamation of that database is what gives rise to that separate right. So that's the introduction to subsistence. The other important point to emphasize about subsistence is that ideas are not protected and concepts are not protected. It's the expression of the idea or the fixation of the idea that attracts copyright protection. So if I go down onto the riverbank at sunset and I take a picture of a bridge and I make all of these creative choices about where I'm going to place the camera, what lens I'm going to use, the angle, the sunlight, all of those creative choices, that's all of my skill, labor, and judgment that I've put into the creation of that copyright work. But it's that copyright work, that photograph, that's protected. The concept of taking photographs of bridges at sunset is not protected, and I can't exercise monopoly control over that for obvious reasons. Similarly, if I have a recipe that I want to protect, or if I have maybe a teaching methodology or a training methodology or a consultancy methodology or any sort of idea, the idea itself is not protectable by copyright. It may be protectable in other ways, in other areas of law, if it's confidential and proprietary, but copyright will not protect the idea itself. So if I write down that recipe into a book, if I write down that teaching or training methodology or consultancy methodology into a paper, that expression of the idea or concept will be protected, and I can prevent someone from reproducing the literary and artistic elements in that book, but I can't prevent someone from, for example, taking the recipes or taking the methodologies and using them in their own business. The next important thing to talk about for copyright is ownership, because there is no registration requirement for copyright. It's not like a patent or a design or a trademark where you file something and you get a certificate and the scope of your protection is all there on a publicly accessible register and on a registration certificate. It's not like that with copyright. Copyright arises automatically, either as a result of authorship or as a result of an author being in employment. So if the author or creator is an independent service provider, a freelancer, like an independent graphic designer, then the copyright in whatever work they do will be automatically. And similarly, if the author is an employee acting in the course of their employment, so an in-house graphic designer employed to do graphic design work and doing that work, then the copyright in that work that they do will be automatically owned by their employer. The other important point to talk about with ownership is that it can be transferred either before or after the work is created. And the significance of that point from a practical perspective is that if you're employing someone or freelance, you want to make sure that that contract has an IP assignment clause or an IP license clause that reflects whatever that arrangement is. And if it's being put in place after the work has been created, you want to make sure that the language that you use is sufficiently specific to capture all of the work that has already been created. If it's a forward-looking agreement, like an employment contract, you don't yet know what exactly that person will create. Again, you want to make sure that the language is sufficiently broad and inclusive of everything that person does in the course of their employment or in the course of their work. There's no registration requirement, as I said above, and copyright generally lasts for 70 years after the death of the author, although a shorter period of protection may apply. In the case of certain works like broadcasts are protected for 50 years only. And similarly, if the copyright work is a very old work, it may be that it was created under the 1956 Copyright Act rather than the Copyright Act, in which case we may need to go back and look at earlier legislation and see whether a shorter term of copyright applies. But generally speaking, the position is that copyright is for 70 years. So we've established what the right is and why it's useful and why it's important, but what rights do copyright owners actually get? Well, there's two categories of rights. The first category is economic rights, which is to do with the buying and selling and commercial activity relating to the right, and the second relate to the author as a person and their reputation rather than the work per se. And I've listed some of the main economic rights there. You have the exclusive right to copy the work, to distribute copies, to rend and lend copies, to perform or show the work in public, to make the work available to the public by broadcasting or sharing online, to create adaptations of the work. And moral rights are things like the right to be identified as the author, the right to object to derogatory treatment of the work, and the right to object to false attribution, to have the works said that the work was created by someone other than you. Turning then to consider the question of copyright infringement. Copyright is infringed if any of those acts that I just listed on the previous slide, copying the work, distributing it, and so on, is done by someone other than the copyright owner or without their permission in relation to the whole or a substantial part of the copyright work in question. So there's two elements that you have to establish. First, you have to establish was there direct copying, direct or indirect copying, and secondly, was that copying done in relation to the whole of the work, so just a carbon copy, taking a photograph and reproducing it identically, or a substantial part of the work. And needless to say, if it's carbon copying, it's usually quite straightforward to establish at least that element of the infringement. The substantial part analysis is more tricky. But there's two elements to unpack there. So the first is copying. You're not usually going to have evidence of copy or hard evidence of copying in the sense that you saw someone do it. You have a video of them copying something, or you have a screenshot of them doing it, or they've confessed to it in a witness statement. So usually you have to infer copying from the evidence that you do have. And there's two things that you look at. First, you'll say, did this person have the opportunity to copy the work? That may be just because it's in the public domain. It's on the internet and everyone has access to it. Or it may be that the person who you're accusing of copyright infringement, a former freelancer, they were actually involved in the creation of the original work, and so they had access. Maybe they had files or information on their personal device. So that's the first element that you look at. And the second thing that you look at to infer copying is striking similarity. And the question that you want to ask yourself is, are the nature and the number of the similarities between the original work and the alleged copy such that they must have arisen by copying and not by coincidence? An example is, let's say you have a 50-page document, and on page 47 of the document there is a spelling mistake, or there's a very, very specific turn of phrase or something unusual in that. If that error is repeated or replicated both in the original and the copying and the copy, or the alleged copy, then that's pretty strong evidence of copying, because it would be quite unusual for that precise mistake or that precise unusual turn of phrase to be replicated both in the original and in the alleged copy. And so you look, and that's looking at the nature of the similarities, and then you look at the number of the similarities and you say, well, if that type of replication or copying has happened multiple times throughout that document or multiple times in that database, that artwork, then that's fairly good evidence of striking similarity from which you can infer copying. And then I suppose the defense to that is if the defendant has a good account of their own process. Well, you say there's all these striking similarities, but here's all this evidence over here of how I came to arrive at my own separate work. And then it would be a question of fact for a judge to decide which of those two stories she or he believes. So that's the copying piece. And then proving substantial part, again, it isn't an easy process. It's something that's going to be decided on a case-by-case basis, and it's quite fact-specific. But it is both qualitative and quantitative. So we often hear these stories about people saying, well, if there's 5 differences between the two works, it can't be copyright infringement. All you have to do is make, a few tweaks. Some people say it's 5, some people say it's 9. And that means it can't be copyright infringement. That's wrong. That's definitely wrong. So if you've heard that, put that out of your mind. Neither is it a percentage-based test. If it's more than 25%, it might be copyright infringement. If it's more than 50 or 5%, it's definitely copyright infringement. That's wrong as well. So put that out of your mind too. It's all a question of where does the skill and labor and judgment and intellectual and artistic creation of the author reside. As you could have an artwork which is 12 inches by 12 inches, and all of the artistic and creative bit could reside in one relatively small part of that piece of art. And so by replicating that piece, you mightn't even be replicating 10% of the artwork, but you could still be taking a substantial part of that art. So it's very important to understand that it's both qualitative and quantitative. And just to illustrate the point, I've included 2 examples there of copies or alleged copies that, in my view, would constitute copying, because you have both from a quantitative perspective and from a qualitative perspective, the nature of the elements that are copied would give rise to an inference of copying because they're striking similar. So that's the infringement piece. Moving on then to defenses or exceptions. So if you're someone who's thinking about how do I avoid an infringement claim, the first thing to do is investigate subsistence. Is this an original work, or is this a work to which copyright attracts in the first place? Investigate duration. It's possible that copyright has expired. Investigate ownership. Perhaps you actually own the work or have the right on the basis of an assignment, or investigate permission. It's possible that you or someone in your organization has a license to use that. If none of that works, if it is a copyright work, it's still valid, there's no assignment, there's no license, then you need to look at infringement. Does what I've done actually constitute an infringement? Has there been copying? And has a substantial part been taken? And if none of that works, then there are exceptions to copyright infringement, things which would otherwise constitute infringement, the fact that they are stated statutory exceptions. And there are a number of them. I've listed criticism, review, quotation, news reporting, and parody. There isn't a statutory definition of fair dealing, but to put it simply, it's use of the copyright work in a way that is fair to the copyright owner and for a purpose that is justified. And so I suppose the argument is that for something like criticizing the artistic work is as important as the right that protects the art itself. Similarly, the freedom to report in the news is another important right that is equally important to protecting art, and so on. But there are rules and regulations that attach to fair dealing exceptions if you want to avail of them. One of which is that the work actually has to be fair. You can't use more of the work than is necessary for your purpose. You have to give sufficient acknowledgement to the author if that's possible. The other fair dealing exception that I wanted to talk about on its own is the educational use exception, because it became very relevant in the last year in the context of teachers and schools wondering whether they could photocopy documents or send documents or copyright content to students outside of the school environment for the purposes of teaching and instruction. But it's that fair dealing exception that was relied on for a lot of that activity that would have happened in the last year or so. So those are the exceptions. Turning then to consider the practical points of things that authors or creators should think about when they're putting their own content online. The first important point is keep records of your creative process. No photographs, keep correspondence. You should have hard copies and digital copies if possible. If you can't have hard copies, definitely keep digital copies of things, because they're going to be automatically dated. You can, and they're scanned in, you have them all there. And the significance of keeping records is the fact that there is no registration process for copyright. So if it comes to proving ownership, either in the context of a licensing arrangement or selling your copyright works or enforcing your copyright, having that evidence and proof of ownership is going to be crucially important. Secondly, use watermarks, use copyright notices when putting information online. The nature of what you do will depend on, what you do will depend on the nature of the work and the platform you're using. But if it's YouTube, if it's Facebook, if it's Instagram, it's easy to put a copyright notice in the description. If it's possible to put watermarks on photographs and videos, you should try and do that. If you are, for example, selling copyright content online, let's say you're a trainer or an educator, or you're providing some sort of consultancy and you're making copyright materials available, you might decide to do something more even more safe than that by making documents password protected, by stating on the document this was licensed specifically to Joe Blogs on X date, not for redistribution. And the purpose at that point too is about asserting your rights. It's about avoiding any sort of defense later on that this was innocent infringement, that it was unintentional, that it wasn't known. You want to make it really clear to users out there online that you're aware of your rights, that you're asserting your rights, and that you're going to take action if those rights are infringed. The third point is, and it might seem like a flippant point, but expect infringement. In the online realm, there is a lot of copying, there is a lot of sharing and distribution of materials. So you should conduct searches for your own materials if you can, so that you're on the lookout for infringement. And then if you do find infringement, you should take evidence of it if you can, by taking things like dated screenshots. And finally, take action. If you do find infringement, you should down where possible. You should take advice if you can, and if necessary, if it's escalating and if it's serious, you should send some sort of a cease and desist letter. And you may not avoid infringement in all cases, but at least if you're someone who has a reputation for defending their rights and taking action where they're infringed, you may prevent escalation and further damage to your rights in future. So turning then to consider points for others, other people who are putting copyright content online. The first consideration is, do you own the content? If you are someone who's working in publishing, for example, it may be that your organization actually has an assignment in their standard publishing agreement and you have the right to put that content online. But it would be important to check the details of that assignment clause and that publishing agreement to make sure that you do actually have the rights, and that you don't just have the rights for paper versions, for example, that you actually have digital rights. If you don't own the content, check whether you have permission or a license. And again, if you're someone who's working, if you're managing collections, if you're managing databases, if you're managing archives, it may be that the standard terms and conditions for the content being incorporated into that library or collection or archive in the first place contain the license. But again, it's really important to check the terms of the license and to make sure that what you're proposing to do with the collection, if it's some sort of reworking or reuse or commercialization that might have been intended at the outset, you're going to want to check the terms of that license to make sure that that what you're proposing to do is actually covered. Then if you don't own the content and if you don't own and you don't have permission, the next question is there actually an infringement? Is this a copyright work? Is it original? Is it the type of work to which copyright is attached? Has copyright expired? Am I taking the whole or a substantial part of the work or not? And if none of that applies, if you think there is a potential infringement, then your final port of call is to check whether there's an exception. Is it possible for me to just use a quotation and rely on the quotation exception? Is the purpose of this exercise some sort of criticism or reporting? Is that the nature of my organization? Are there any fair dealing exceptions that I can rely on here? And if I am intending to rely on those exceptions, am I complying with the requirements of fair use in the instance I'm using no more than is necessary for my purpose, and I'm giving proper attribution. Further considerations for other people sharing third-party content online. I wanted to make specific reference to this because it was a bit of a hot topic. It's hyperlinking. If you link or embed content that's freely available online, then there's no infringement because you're not communicating it to a new public. You're not making it available to people who didn't have access to the content before. But if the copyright owner requests its removal, then you must take it down. You must take your linked version of that work down. And if you fail to do so, then that does constitute infringement. And similarly, it will constitute infringement if you're trying to make or pursue financial gain from that work where it was freely available before. Then if you are sharing or embedding or hyperlinking to content that's not freely available online, so if it's content behind a paper, that obviously is infringement because you are communicating to a new public. You're making the work available to people who didn't have access to it before. And then lastly, if you're linking to licensed content, again, it may or may not constitute infringement, a bit like I said earlier about checking the terms of the license. Different types of licenses and different types of content will have different terms. And the Creative Commons licenses, for example, have different terms for different types of work and for different types of use. So depending on what commercial use. So again, it's really, really important that you check those license terms if you're planning on sharing through embedding or hyperlinking or otherwise licensed content. And before we move on from copyright is to speak about the directive on copyright in the digital single market. As many of you may know, just from reading about this over the past couple of years, this is a directive that was introduced in the EU, and it was essentially designed to protect European copyright owners and content creators from big US tech giants. And there were a number of provisions, obviously, in the directive, but two got a lot of airtime, and they are Article 15 and Article 17. Article 15 was a provision that was designed to give newspapers more direct control over the reuse of over the reuse of their work, their news items. And so it imposed restrictions on news aggregators, Google, on their ability to aggregate and share news. And I suppose the reason it was controversial is because there was a free speech argument and a free press argument on the part of people like Google who wanted to be able to freely disseminate all of this information, whereas newspaper organizations argued that they were losing out on potentially subscription revenue because people weren't signing up to their subscription services if they were using these news aggregators instead, and also just potentially losing out on licensing, just the ability to negotiate better licensing terms with people like Google. So that became controversial for that reason. Article 17 was the other section of that directive that was controversial because it imposed obligations on providers like YouTube who host user-generated content to try and prevent copyright infringement by having things like upload filters. And again, there was arguments that this would be on YouTube. There was an argument that it would prevent free speech. There was an argument that these types of upload filters would have false positives. So they would catch things like parodies, for example, which are legitimate, but would flag them as infringements. And so those two provisions are relevant to our discussion because they deal with content sharing online, but they were controversial. The other important point is that they're both provisions in an EU directive. So not directly relevant to us now because we left the EU before the implementation deadline, but some of them have been implemented into the laws of the other EU member states, and some of that is ongoing in other countries. So I guess it remains to be seen whether how it will impact us, the implementation in other EU countries, and whether we will have a version of the directive implemented into UK law at some point. Although the current position of the UK government is that they won't be implementing that directive. So that's the copyright section, and I'm conscious that we're about halfway through now. So hopefully the data protection and trademark sections will get through a little bit quicker. The second section is data protection, and we're speaking about privacy rights relating to online content. And the first, in 1995, the EU Data Protection Directive came into force. And if you cast your minds back that far, this was when we had kind of Windows 95 and dial-up. If someone picked up the phone, you got knocked off the internet. There was eBay. There might have been Amazon, but there wasn't Google, there wasn't Facebook, there wasn't Instagram, there wasn't smartphones, there was none of that. And so over the next period of, say, 20, 25 years, from 95 onwards, there's this massive leap forward in terms of technological change that transformed every aspect of our lives, including our commercial life, our activity. And so by 2011, the European Commission and the European Parliament had identified the need for a complete and total overhaul of the way that we deal in personal data in Europe and the way that we respect the privacy rights of European citizens. And during the course of that 4-year period, 2011 to 2016, there was a lot of discussion, a lot of debate, a lot of disagreement, a lot of lobbying in Europe between the Commission, the Parliament and the Council. And if you go back to the history of it, the drafts of the regulation were really, really quite different during the course of that 4-year period. But ultimately, the GDPR was published in 2016 and it became law in 2018. And one of the big significant points about the GDPR was that it was a regulation as opposed to a directive, which meant it was directly effective in the European member states immediately without the need for any implementing domestic legislation. And then the final piece in the puzzle was in 2020, the UK left the European, but at that point, the GDPR had been part of our domestic law for 2 years. Most people and businesses had already made all of that adjustment. And in order to facilitate the free exchange of data between the UK and the EU, and in order to ensure that we would get an adequacy decision from the European Commission, we essentially just incorporated an almost identical version of the GDPR into the Data Protection Act 2018, and that's the UK version of the GDPR. Moving on from the timeline just to a few key concepts, and apologies if I'm saying things that are obvious here, but I think it's worth emphasizing these points. Personal data is any information relating to an identified or identifiable natural person or living person. So it includes photos, videos, and any other unique identifier. So a name, an address, a date of birth, a phone number, an email address, social media, account name, a profile name, or a device ID if it identifies that person. So you have a really, really super broad definition of what constitutes personal data. A data subject then is a person, an identifiable natural person in respect of whom personal data is processed. A data controller is any natural or legal person, so it would include a company, who determines the purpose and means of processing personal data. So it's basically anyone who makes decisions about the processing of personal data is likely to be a controller. And a processor then is somebody who processes on behalf of a data controller, doesn't make decisions themselves. So if you outsource your IT service provider, or if you outsource your payroll function to someone else, you give them specific instructions on what to do with your data, but they don't make any decisions themselves. Then that person is a processor, not a controller. The last definition is the definition of processing. Is any operation or set of operations which is performed on personal data. It includes collection, storage, transmission, adaptation, alteration, and even erasure or destruction. So it's again a really, really broad definition of processing, and it, the GDPR was very intentionally drafted in this way so that its scope would be very broad, and that any identification of a data subject would come within its scope, and almost any processing activity would come within its scope as well. And then one of the biggest questions for people putting their own data online, or for someone processing someone else's data, is what is the legal basis for that processing? And there was a lot of discussion around the time the GDPR came in, because the consent requirements were becoming more strict. You couldn't have opt-out consent anymore. You couldn't have bundled consent. It had to be really specific. It had to be informed. It had to be unambiguous. And so people wondered and worried about, well, how are we going to comply with these consent requirements? But actually, it is not now, nor was it then, the case that there is only one legal basis for processing personal data. There are multiple bases, and I've set out 4 of them there. The first is consent, and if you are going to rely on someone's personal data online, or to do any processing in relation to someone's personal data, it must be freely given. It must be specific, informed, and unambiguous. So it must be really, really clear what data you're processing, what purpose you're processing it for, what you're going to do with it, and so on. And there must be either a clear statement or there must be an affirmative action like a click button or a tick, and it must be opt-in. It can't be pre-ticked or pre-clicked or something that the data subject has to notice and opt out of. If you're not relying on consent, it's possible to rely on contractual necessity. So if there's a contract for the delivery of goods, for example, and you must process that person's name and address to deliver those goods, then you have a sufficient legal basis to process that data for that purpose. Similarly, you may have a legal obligation to process someone's personal data in an employment context, in a tax context. And lastly, a really, really useful basis, if consent isn't possible, is the legitimate interests test. And this is where either the data or someone else has a legitimate interest to be pursued. And the only way of pursuing that personal data is through the processing of, the only way of pursuing that legitimate interest, rather, is through the processing of personal data. And you're satisfied that your legitimate interest doesn't override or overburden the data subject's rights and freedoms. And an example of that would be debt collection. A creditor may need to, or a debtor rather, may need to process personal data to chase a debt, but the person who owes that money wouldn't necessarily give you the consent to process their name and address. And that would be a really good example of a situation where you have a legitimate interest in processing that person's personal data without their consent or without another legal basis. So turning then to consider what rights data subjects actually have. Again, they're quite broad. You have the right to request access to your information, to request that it be corrected or deleted or transferred to another data controller. You can object to processing if the processing was done on the basis of legitimate interest. You can withdraw consent if the processing was done on the basis of consent given previously. You can object to any automated decision-making like profiling, and you can complain to the supervisory authority, which in the UK is the Information Commissioner's Office. And you have an absolute right, as has been well publicized now, you have an absolute right to opt out of direct marketing regardless of the legal basis on which it was originally done. So if you consented to something previously and you're still receiving emails or text messages that you don't want, the data controller is supposed to allow you to opt out at any time, and they're supposed to facilitate that opt out and make it as easy for you to withdraw consent as it was to give consent in the first place. So we've spoken about the data subject's rights. The opposite side of that is the data controller and processor's obligations. The first and principal obligations are relate to the data protection principles as set out in the regulation, and they are that processing must be lawful, fair and transparent. So you must do things like registering with the ICO, having a legal basis to process, facilitating data subjects' rights. Purpose limitation means that you can only process personal data for a specified legitimate purpose. Data minimization means that you can process no more data than is necessary, and storage limitation is that you process data for no longer than is necessary. Security, integrity and confidentiality is about having appropriate organizational and technical measures in place and to notify and report data breaches. Accuracy is about keeping data correct and up to date, and accountability is about complying with all of the above rules and demonstrating compliance through things like documentation, which I'll come on to speak about now. And the main documents that you need to have are, again, as is well publicized, a privacy policy or a privacy statement setting out the basis of your processing, a data processing agreement or a standard contractual clause if you're transferring data to a processor in the UK or outside the, or sorry, in the UK or EEA or outside the UK or EEA. An internal processing record setting out all your processing activities, an internal breach record. If there have been data breaches, you're required to keep a record of that as well. A data protection impact assessment if you're carrying out a project or any other processing activity that carries a particularly high data protection risk. So if you're processing data on a massive scale, for example, or if you're processing data in a way that the data subject might not expect, then it would be necessary to go through that risk assessment and make sure that you were satisfied you had a legal basis, that you could proceed, that you'd taken all the necessary risk mitigation exercises. And lastly, the legitimate interest assessment, which isn't strictly provided for in the text of the GDPR, but it's well established in practice now that if you're going to process not on the basis of consent or contractual necessity or legal obligation, if you're going to process on the basis that you think your legitimate interest outweighs the data subject's rights and freedoms, and if you're satisfied that it is necessary, then you have to document that assessment and show how you arrived at your decision to proceed with that processing. So, subjects putting their own content and information online, the first question is: does the content uniquely identify you, and so does GDPR apply in the first place? The second is there a privacy policy? And does it say, and do you know basically what the legal basis for processing your personal data actually is, and how it will be used, how it will be shared, how you're going to exercise your right to withdraw consent or to make an objection or to exercise any of your other rights? If the legal basis is consent, you do have the right to withdraw that consent at any time. And if the basis is legitimate interest, you have the right to object to that and to ask, for example, for a copy of the legitimate interest assessment, or the basis on which that decision was made. And you can exercise any of your GDPR rights at any time. You can request access, correction, erasure, or transfer of your personal data. And you can make a complaint to the supervisory authority in the UK, which is the ICO. Points for people putting content or personal data in relation to others online. Again, the first question is: does the content that you're putting up uniquely identify someone? If it's photographic content, if it's video content, if it is text or any content, does that actually apply? And do you need to comply with the GDPR requirements? If you do, the first and probably most important question to ask yourself is: do you have a legal basis for processing? Is there a documented consent process? Or have you completed a legitimate interest assessment? Or are you satisfied that there is contractual necessity? Are you satisfied that you have a legal obligation to process this person's personal data? Do you have all the applicable in place? So do you have security measures, organizational and technical measures? Are you responding to subject access requests? Are you notifying and reporting data breaches? And lastly, do you have all the documentation in place? Have you a privacy policy, an internal processing record, a breach register, and so on? And the point to note about the GDPR as a general sort of takeaway is it's very much about self-assessment. It would be unusual, particularly for small businesses, to have much interaction with the ICO, because they're not going to be going to the ICO whether there needs to be a prior consultation, whether they need to appoint a data protection officer, whether they're doing something which is particularly risky. So the first time that your data protection processes are likely to come under scrutiny is when a complaint is made. And it's at that point that you need to be able to open your books and say, yeah, we're squeaky clean. Here is our privacy policy. Here are all our processes. Here is everything documented from start to finish. And we're very, very happy over how we've dealt with personal data in the past. So yeah, it is very much a self-assessment exercise. And as a matter of good practice, you should be taking those points into account. Moving on then to the third and final section, which is trademarks. Trademarks are marks or signs which are designed to signify the source or origin of goods and services. So in other words, these are the brand identifiers customers use to find you or use to find your goods and services. In order to function as trademarks, in order for customers to actually use them to find you as opposed to anyone else, trademarks have to be distinctive and they can't be descriptive. So if you're a restaurant, you can't have a trademark that is the restaurant. If we're a law firm, we can't have a trademark that is the law firm, because it's too non-distinctive, it's too descriptive. It's not, that word or that phrase isn't going to distinguish us from anyone else. But it gives the owner the right to prevent others from making unauthorized use of that trademark, subject to three main limitations, which is that you only have monopoly control over the mark as it was registered, whether it's a word or a phrase or a logo. The trademark limitation only applies in relation to the goods and services covered by that application or that registration, and it only applies in the territory where the registration was sought. So there's three aspects that limit the scope of the trademark monopoly. Trademarks come in all shapes and sizes. I've given a few examples there. Brand names, headline brand names like Kellogg's would be a trademark. Then sub-brand names or product names would also be trademarks like Cocoa Pops. Slogans and lines, shapes and colors. There are others now as well. Sounds can be trademarks. Smells can be trademarks. Moving images. Any sign or is capable of identifying the source or origin can, in theory, function as a trademark, subject to certain restrictions. But the main two that will apply to almost businesses will be a word mark and a figurative mark, because every business has a name. It's the thing that you say and speak and type and hear and find someone verbally. And figurative marks, so logos, visual identifiers, most businesses will have them. And so when you're thinking about, if you are the brand owner and you're thinking about what you want to protect, word marks are important because they give protection for the word itself, regardless of size, regardless of color, regardless of font, regardless of any other limitation. So you get very, very broad protection, because if you decide to change your font later or change your color scheme or your style, you don't have to go back and reapply for that word, because that plain text word mark captures every variation of that word. If your word mark is somewhat distinctive or somewhat descriptive, and there's a risk that it might be refused or unenforceable for that reason, word marks are a bit harder. They can be harder to register for that reason if they're descriptive or non-distinctive. On the flip side, then, figurative marks or logos, their protection is narrower because it's limited to that image that you've registered, that particular arrangement, that particular color, that particular font, that particular style. But then it's generally easier to register because that there are added visual, stylistic, color, font elements. It makes the mark more distinctive. It adds an additional visual layer of distinctiveness to the verbal layer if there's just a word in that mark. And I've included a couple of examples of sort of parodied trademarks there to demonstrate the point that you need both. If YouTube only had a trademark for YouTube, the word mark, but didn't have protection for the elements, the visual elements, then they may not have been able to prevent the you suck trademark, which replicates the visual elements. And the same applies for McDonald's and McDiabetes, Amazon and Money's Gone, Ford and Fail, Diet Coke and Diet Joke. So if you're a brand owner and you're thinking about protecting the different aspects of the brand, it's important to look at verbal elements. What do you say? What do consumers hear and type and search when they look for us? That's the verb. And then what is the visual brand identity? What do consumers see? What do they remember? And as these examples illustrate, you can have a company brought to mind just by a color or a font or an arrangement. You don't necessarily need the word. So it is very important to protect both elements if you can. Turning then to consider trademark infringement and passing off. What happens when you have the trademark and the right is infringed? The first type of infringement is where somebody sells an identical service under an identical mark. That's straightforward, clear infringement. You don't even need to prove confusion. You just need to show that the goods being sold out there are identical to the goods in your trademark registration, and the mark on those goods is identical to your mark. The end. Likelihood of confusion is where you don't have double identity, but where you have similar marks or where you have similar goods. And then you have to prove, right, they're not identical, but we still think because of this similarity between marks and between goods and services, consumers confuse one for the other. Either direct confusion, where a consumer actually thinks product from company X is actually a product from company Y, or indirect confusion, where companies or where consumers rather correctly distinguish between the two marks and the two brands, but they assume wrongly that they're connected, that they're sister brands or sub-brands. There's some sort of economic connection between the companies or the brands because of the close similarity between the marks. Then you have causing detriment to a trademark with a reputation, and this can arise whether the goods and services are similar or not. So if I just started selling Bentley pens, Bentley could argue that I am blurring or diluting or tarnishing their reputation by selling a cheapy product under a luxury brand name. And so the issue isn't confusion. The issue isn't that people think that I actually am an agent of Bentley. They will just see that trademark as undermined and damaged because it's lost its exclusivity and its luxury status. Unfair advantage or free riding is the same point. Again, it can happen regardless of similarity between goods and services. It's just by virtue of the fact that there is a trademark out there with a reputation. Somebody could potentially come along and sell completely different goods under the same brand or a similar brand and just benefit from well-established trademark with the reputation purely by virtue of the fact that consumers recognize it. So that's a form of infringement. And then lastly, passing off is the one that's not like all the others. It doesn't exist under the Trademarks Act. It's a common law. It's a common law cause of action, a tort. And it arises where somebody makes unlawful use of an unregistered trademark. So even if you've never registered anything, but you can show that you've been trading for a very long time, you have a really well-established brand name in the UK, and you can show that because of that well-established trade and goodwill and reputation, consumers will be misrepresented to or will be deceived into believing that a competitor's product or brand is your product or brand, then that's another form of unlawful use of a trademark, but in this case, an unregistered trademark. And then what are the defenses and exceptions to trademark infringement or passing off? Well, the first is if a person wants to set up a business using their own name or address, it has to be a natural person, a human person, as opposed to a company, they're allowed to do that. And that's just balancing the rights of individuals to trade under their own name with the rights of trademark owners to exercise their rights under the trademark monopoly. The second major exception is in relation to descriptive use or referential use. So if there is a trademark for a descriptive term, and then you use that term descriptively, not to refer to that person's, not to refer to a trademark or a brand name, but just to describe a product, then that use is acceptable, provided that it's being done honestly and in accordance with honest commercial practices. And the referential use exception is if you're using the trademark just to refer to that person's product. So you're not selling a competing product or a counterfeit product, but you're perhaps reselling that person's product or just referring to it, then that use of the trademark is as well. The third exception relates to exhaustion of rights. And this basically says that if you resell legitimately purchased branded products online, that's permitted. So if I buy a can of Coke and decide I don't want to drink it, but I'm going to sell it on Amazon, I can put that trademark onto Amazon and say, I am selling a product that I have in my hand. I'm allowed to do that because the rights of the trademark owner are already exhausted. Coke can't then come and say, you're not allowed to use trademarks and register the product. I say I am because the products are already on the market. The exception to that is parallel imports. Number one, if you buy a product in one territory, say in the US or in another territory, and you bring it into the UK or the EEA and sell it here, then it is possible to object to that because there are different trading conditions and different prices in different territories. And similarly, if you make changes to products or to their packaging, that's an exception to the exhaustion rule as well. So let's say I buy my can of Coke, I empty the Coke out of it and turn it into a Bluetooth speaker, and then I sell it as a technology product under the Coke brand. Then I can't argue that I'm just reselling a product because I'm not just doing that. I've changed the nature of the product itself. So it's an exception to the exhaustion rule. Other potential responses to a trademark infringement or passing off claim are invalidation of the trademark. You could argue that the trademark should never have been registered because it was descriptive, or you could argue that the trademark should never have been registered because someone else had prior rights. Maybe you had prior unregistered rights, for example, under passing off law. Or you could argue that the trademark should be cancelled because it hasn't been used in a very long time or for more than 5 years. If you can't argue that, you could argue that there's no confusion, there's no reputation, there's no detriment, there's no unfair advantage, and use that as a defense to trademark infringement. And if you're arguing against a passing off claim, you could argue that there is no goodwill because actually this person doesn't have trading history they say they do. Or they could say there would be no deception because consumers will easily distinguish between the two products and brands, or you could say that there would be no damage. So there are a number of defenses to claims for trademark infringement and passing off. And the practical points for brand owners or content owners putting their own content or their own branded content online. The first thing I would say is carry out clearance searches on Google, on social media, on trademark registers, on Companies House, on news websites, to see what other products are out there and to see if it's likely that by putting a new brand online, or indeed an existing brand online, that you're likely to come up against a complaint from another brand owner. And if clearance searches are clear, then you should go ahead and try and secure trademark protection so that you have a registered right, a registration certificate for your own trademark. When you're then putting your trademark online, you should use either the TM symbol if it's an unregistered trademark, or the registered or symbol if it's a registered trademark. And again, a bit like the using copyright notices, it's about asserting your rights. It's about putting people on notice that this is a trademark, that you're aware of your rights, that you will enforce your rights. You should also retain evidence of use of your trademarks online so that you have a defense if they're ever challenged for non-use. And again, a bit like copyright infringement, you should retain evidence of infringement online by taking screenshots, and you should take action in the form of takedown notices and cease and desist letters of any trademark infringement or pass off online. And then points for other people putting branded content online. The first thing I would say is, does the content actually contain any trademarks? If the content does, do you own the trademark, or does your organization own or have permission to use the trademarks? For example, is there a license already exhausted? Is it legitimate reselling of branded goods that your organization is involved in? And what is the nature of the trademark use? Is it actually used as a trademark, or are there any defenses or exceptions that you can rely on? Is it referential use? Is it descriptive use? Or is there exhaustion? And if none of those three apply, the next question then is, does what I'm doing actually cause confusion? Does what I'm doing actually cause detriment? Is there actually an infringement here? And again, that's a question of fact that would need to be determined on a case-by-case basis. If you're at the point where you're thinking of putting, where you're thinking of using a trademark without a license, without any defense, it would be useful to kind of take advice at that point. And the fifth and final point, which is a sort of practical point, is if you do receive a complaint, if you receive a cease and desist letter, respond to it. Don't ignore it. Don't put your head in the sand, because you may end up with claims of flagrant infringement and things like that, which are not good for you and not good for your business. Also, again, I appreciate that I was going at speed, and it's a bit of a whistle-top tour of these three rights, and the three of them are huge areas where you could talk about them for hours. Copyright, it's a very, very broad right. It's a flexible right. It's hugely important and hugely useful for businesses. It arises automatically, so it doesn't cost anything. There's no registration, so you don't have to wait, and it covers a huge spectrum of categories of content. So before you put content online, the main thing to remember is check whether you have the right to do so, either because you or your organization are the owner of that copyright, or because you or your organization are the licensee, you've got permission to do that. And if you don't have any of that, take advice, but check whether there are exceptions or defenses. But I would say take advice before you decide whether to proceed and potentially put the organization at risk. In terms of data protection, as I said, cataclysmic change over the last 20 years in data protection law, and the rights were massively enhanced by the introduction of the GDPR. So before putting content online, check whether doing so will actually involve the processing of personal data. And if it does, what's the legal basis? Do you have consent? Do you have a legitimate interest assessment? And if you do, and you're happy to proceed, make sure that you also have all of those processes and procedures and documentation in place. Trademarks are really, really important. If you set up your own business during the pandemic, if you're dealing with other people's brands, these are really important assets that prevent infringement and unauthorized use of brands by third parties online. So before putting content online, you should check whether any trademarks are in use. If they're your own trademarks, you should do clearance searches and register them. And if you're using other people's trademarks, check the nature of that use. Are you using it as a brand identifier, as a trademark, or are you just using it to refer to an existing brand or to describe an existing product or brand? And the answer to those questions will determine whether what you've done is likely to give rise to a trademark infringement claim or a passing off claim. So those are my final thoughts, and I'll circulate the slides afterwards so that you have all of that and more contact details if you have any follow-up questions. But now I think, Bav, we have half an hour if people have questions. So I guess I'll hand that over to you. Do you want me to stop sharing my screen? Would that be easier?
Yeah, that would be easier, actually, yeah. Now, that was a lot of wonderful content there. Thank you so much, Eamon, for taking out time. I know you've put that together especially for this event and for the Knowledge Quarter. So that was you probably spending yesterday all evening, all night putting it together. So I appreciate all that time you've put into it. I also appreciate a lot of that stuff would be, some of it would be familiar, but a lot of it would be kind of new, lots of terms and references and titles that might go over our head, especially at the speed at which we were trying to get through all of it. We've got about half an hour now, so we can really sort of try to rein it back in again. If there are any kind of questions, even if they sound like really silly questions, you know, don't be shy. I would ask any partners and anyone attending this to sort of raise their hand or put their camera on or something, and actually you can ask the question yourself and have a little bit of a back and forth with Eamon if that's easier, rather than me reading out things from the chat. So if anyone is brave enough to just put their questions to Eamon right now, let me know. Otherwise I'll read the few that are in the chat. Okay, we have. I'll start. So Rebecca asks, if a Crown servant rather than an employee creates something in the course of his or her work, who owns the copyright? For example, who owns the copyright? There's a question. So for example, a police officer has a role as a crime scene photographer. Who holds the copyright?
That's a really good question. I suspect the default position under the Copyright Act is that the copyright would be owned by the Crown. Assuming that that's your ultimate employer, I'd need to understand maybe the structure of the police force and exactly who you're working for. But the assumption would be that it's the employer, and in this case, I'm going to assume that's the Crown. If there's no contract in place, the key phrase in the legislation and the key phrase in case law is in the course of your employment. So if you're a police officer who is not somebody who ordinarily takes photographs or writes materials or creates any creative content like that, but maybe you're an amateur photographer on the side, or you're an amateur software developer or whatever, then there potentially is an argument there that what you've done, even though you are an employee, what you created was not in the course of that employment. That's not something you were ever employed to do, and there's no reference to that in any job description. I'm assuming in that scenario there is an employment contract, and in most employment contracts, certainly the ones that we would be drafting for employers, we would be trying to draft that as broadly as possible. So we would be specifying that any creative work that you undertake, which is used in your employment or which is capable of being used in your employment, whether you do it on your own device or on our device, whether you do it on our premises or on your own home or other premises, whether you do it inside of working hours, outside of working hours, that's going to be owned by us, because in that scenario, that's our job, is to get everything in for the employer. So yeah, that's a very long-winded way of saying I suspect in that case the copyright is likely to be owned by the Crown.
Okay, cool. We have a question from Nicole, who works at the British Library. Does GDPR apply to the personal data of someone who is deceased? And if so, for how long after their death?
No, to my knowledge, GDPR only applies to the processing of personal data in relation to living individuals. Yeah, I'm 99% sure that's the case. I'm not sure if there's any exception for people who are recently deceased, but I'm certainly happy to check that point and confirm. But that's my understanding.
Okay, cool. Next question is, how do you complete the application for trademarking your brand business name? There must be a website or something where you can do that, right?
There is. So the first question you kind of want to ask yourself is, where are you applying? If you're applying in the UK only, then you'd be going to the gov.uk website, and you can file an application there. If you want to apply elsewhere, if it's to the EU, it would be to the EU Intellectual Property Office in Alicante. If it's for a federal trademark in the US, it would be for the US Patents and Trademarks Office. So you certainly can do that yourself. I would say, and this is not me hard selling or anything like that. It's not my style. I would say you should at least have a discussion with someone about trademarking before you go and do it, because they will ask you for the fee. You pay the application fee at the point at which you file the application, and if it turns out that it's filed incorrectly, they won't give you your money back. So if you file the wrong version of the image, or if you file the mark in a way that it's not enforceable, or if you pick the wrong class, you may lose out. So I would say, even if you don't want to instruct a lawyer or a trademark attorney or an agent to actually do that work for you, you should at least have a chat with someone about it beforehand.
Sure. Okay. David Brown from Camden Tour Guides has asked, back to copyright. You said material freely available online can be shared. I'm confused by this. For example, if a photo appears on the BBC website, can it be reused if the BBC is given attribution?
So I think I was speaking about hyperlinking and embedding in particular, which you can do if it's freely available online. In the context of the fair dealing, fair use exception, there is a carve out for photographs. So you can't. So yeah, the short answer to the question is, for a photograph, no, you can't. You would have to have a license to use the photograph. But for other works, you can. So for literary works, for example, you can rely on things like news reporting and quotation. The other point about the fair dealing exception is that the nature of the use is relevant. So if you were doing it for commercial purposes, for example, then that's unlikely to be allowed. That's unlikely to be considered fair in the context of the copyright owner's rights.
Can I just ask a couple of follow-up questions on that? And I'm not saying I've ever done this.
Right.
If I'm putting together a conference and it has 40 speakers and I'm trying to find 40 good images for those 40 speakers for my printed brochure and my online website, and I've asked for photos from those speakers and they've not got back to me, and I've asked again and they've not got back to me, and I've Googled them and I found a wonderful high-res image of them that happens to be on some other website or on The Guardian or something else, and I've downloaded it and made it black and white and then put it up on my website. Am I breaking the rules?
Yeah, that's infringement.
Okay.
That's infringement because, I mean, for one thing, you don't actually know that the person who's in the photograph owns the copyright in the photograph. And very often, if you're looking for photographs of people online, it will be the photographer or the newspaper or some other organization that will own it. And in practice, we've seen a huge increase in the number of companies pursuing that type of infringement online and sending out masses and masses of cease and desist letters and asking for standard form compensation based on what use you made of it, how long it had been up there, how widely it was available. So yeah, I suppose as we all know, this stuff happens all the time. The reason it happens all the time and goes unchecked is because very often the infringement is so low level. If it's a private event, if it's a once-off event, if there's no commercial advantage to using that photograph, then it's probably not worth anyone pursuing it. But that doesn't mean that it isn't a technical infringement. If you don't own the copyright and if you don't have a license, and if there's no fair dealing because it's a photograph, then you potentially have an issue there. Okay,
great. We have a question from Conway Hall. Hyman, we put video recordings of our speakers and their presentations at our venue onto YouTube. What is the status of the images or videos they use within those presentations in terms of copyright and our use of them within the video recordings?
So when you say it's a recording, is that a recording like the recording that we have here? Or is it a presentation in the background?
Yeah, I think it could be a presentation, or it could be, say you've shared, in this recording, you shared images, and we've put this video up on YouTube. Are we breaking any rules because you used other people's images?
Yeah, that's true. So I suppose you would want to check with the person who created the presentation to see whether they had permission to use the text and the images and the excerpts that they do. For most of the things that we're using, they're Shutterstock images or they're images that are sort of free to use. So for example, all of the logos and things like that, we're not making commercial use of them. We're using them as trademarks to refer to those legitimate brands. So yeah, I think in that case, you would want to check with whoever created the content to see that they had the relevant clearances, either that they were freely available or they were available under a Creative Commons license, or the person owns the content by having taken the photographs themselves or created the images themselves.
Okay, that's great. Thank you so much for that. Just just based on that, if I search for sort of copyright-free music or copyright-free images to use as banners to promote a knowledge culture event, or to use as music in the background, and a whole load of stuff comes up in Google when I search for those things, I never bother to check if that really is copyright-free. I just trust that it is. Is there ever a case where we might, be using content that actually, how do you check? How do you know for sure?
Yeah, that's true. I suppose you can check and see whether there are copyright notices there. You can check and see whether they are in repositories or services that specifically say we're making this stuff available for free, rather than just going to Google Images. But unfortunately, if somebody comes out of the woodwork later and can prove that they created it, and can prove that you've copied their photograph, image, whatever it is, they do potentially have a claim against you. So I would say rather than Googling free copyright images, it's better to use services like Shutterstock or one of those similar services, so that what you're technically getting is a free license. The origin of the copyright is known and is clear, and what you're getting is a license to use them for free, rather than sort of trusting that this is just something where copyright doesn't attach, or copyright is expired, or the copyright owner has agreed not to assert their rights. There's the difficulty that you have depending on the nature of your use. I mean, I suppose with your use, Bav, if it's just for an event, the likelihood of a complaint, or the likelihood of any serious damages claim, is probably relatively low because of the nature of the use that you're making. It wouldn't be worth pursuing you. But for other people who are engaged in more commercial activities, you could have a situation where you start using something which becomes more commercially valuable than you initially anticipated, like that photograph or that video that went viral. And then the copyright owner comes out of the woodwork later and decides, actually, this is worth pursuing.
Okay, Joe Little from the Art Society has asked, does the copyright of images or videos within a presentation also apply to a live stream, as in not necessarily uploaded content?
So it would apply in that case because it's a broadcast. So it does apply to the live stream, but it applies not as a film or not as a sound recording, but as a broadcast, which is a separate category, which I didn't list in the presentation, but it is a separate category in the Copyright Act. Yeah,
and I know that a lot of KQ partners at the start of the first lockdown, when there was this sort of moment of panic where we have to sort of do something to entertain people who are at home, and a lot of the organizations, certainly from the arts and culture sector, so music, dance, drama, all of that lot, thought, well, we have loads of wonderful content in our archives or recordings, and very quickly they were able to digitize it if it wasn't already, and very quickly upload it onto YouTube or any other sharing platform, and then embed it onto the website. And often some of those performances, those talks, those panel discussions, those poetry readings, whatever they were, music performances, that was just stuff that was in their archive from long before, and it was uploaded. I don't think anyone at that time checked, I'll be doing the right thing. Are there any rules around old content that does belong to you, but at the time when you recorded it, you might not have intended it to be uploaded onto a website? Is there any performers or artists or speakers or poets who were in those videos that we need to go back and check with?
Yeah, so any of those people would have well, it depends. If it's a panel discussion, you may not have a case for performers' rights. But if it would, let's say for argument's sake, it's a dance recital, then yes, that person would have performers' rights. And the best way to secure your ability to put all of that information online is to get an assignment or a license from them for their performers' rights, and at the same time get them to consent to the processing of their personal data.
Fantastic.
So
Brilliant.
yeah, it probably feels like a large exercise to undertake it now. I mean, and again, it's a bit like you look at the legal position and then you look at the practical reality. If I sat on a panel discussion 10 years ago and I spoke about something, let's assume I sang a song or did a dance. I didn't, but let's assume I did. I'm probably in my head, I probably implicitly consented to the recording of that at the time. And I could tell it was being recorded because there was a camera on my face. So even if I didn't sign anything at the time, I'm unlikely to complain about it now, particularly if it's being used in a way that I anticipated. If it's being used by the KQ as part of the KQ's archive or whatever other organization it is, I'm only likely to complain if it's being used in a way that I didn't anticipate or didn't agree to. Like maybe some sort of commercial use. So that's not to say that you don't still need to get the assignment or license, or that you don't still need to get permission for the processing of personal data, and certainly that you shouldn't do it now for future stuff. But that's potentially a reason why these things don't get policed.
Yeah. Okay, fantastic. Well, I don't have any more questions in our chat. I don't have any more on my list. If anyone else has a burning question that you want to ask, please just put your camera on or raise your hand or anything like that. You're more than welcome. Otherwise, I think we've probably come to the end of the masterclass. There's quite a lot to take in there. A few people did ask about sharing of the slides and that kind of thing. So we will share the slides and with Eamon's permission and the recording. We might keep the recording up for a short time, for a limited time. I think I'm not comfortable having it on forever. We'll have it for a short time. But if you have any further questions or if you want any clarification, please, I know Eamon's more than happy to be contacted. I will share his details when I send the slides to everybody who attended today's session. So give us a few days to put that together and share it with you. But thank you all for joining. Do leave any comments or feedback in the chat if you enjoyed this or found it useful, so that we know we can do more of these things in the future. If any of you are from a particular sector and you want someone like Eamon to come and talk to people from your sector, I'm sure he'd be very happy to offer his help in some way. No promises. But all I can say is, thanks massively to Eamon and to everyone at Briffa for your expertise and for sharing all your knowledge and taking out time. This is absolutely brilliant. Thank you so much.
Yeah, very happy to do so, Bav. Thanks for organizing everything. Thanks everyone else.
Fantastic. Take care. Thank you.
Okay. Bye.